Can the police arrest you just for being nervous? Judge David Flecher just gave the Thin Blue Line a reality check they'll never forget.
Step out of the car, sir. I'm conducting a search.
Motion granted. The search was illegal. Case dismissed.
I get nervous when I see a spider. That doesn't make me a felon.
No probable cause. Case dismissed.
In this episode, we explore a fundamental pillar of our legal system, the judiciary's role as a check on law enforcement overreach. We're returning to the courtroom of Judge David Flecher in Harris County, Texas, to witness what happens when the thin blue line meets the firm wall of the Constitution. While police are tasked with maintaining order, their authority is not absolute. Under Article 38.23 of the Texas Code of Criminal Procedure, Texas maintains one of the nation's strictest exclusionary rules. It states that no evidence obtained in violation of the law or the Constitution can be used against a person in a criminal trial. A probable cause hearing is the first line of defense against contempt of cop, arrests, or pretextual stops. As we saw in our previous reviews, Judge Flecher doesn't just rubber stamp an arrest because an officer wears a badge. He looks for specific and articulable facts. When an officer's report is filled with conclusory language, words like suspicious or uncooperative, without factual backing, the system fails. Today, we look at cases where the judge stands as the protector of the people, ensuring that government power is checked and that probable cause remains a high standard, not a hollow phrase. Our first hearing involves defendant Marcus Vance, who was arrested on December 12, 2025, and charged with unlawful carrying of a weapon. The arrest followed a routine traffic stop for a minor equipment violation, but the situation escalated when the officer decided to search the vehicle's trunk. Judge Flecher: Mr. Vance, you're charged with unlawful carrying of a weapon. You face up to a year in jail and a $4,000 fine. You have the right to remain silent. Do you understand? Vance: Yes, Judge. Judge Flecher: All right, let's hear the PC. Prosecutor: Judge, the officer observed the defendant's vehicle with a non-functioning license plate light. Upon approach, the officer noted the defendant appeared unusually nervous and was fidgeting. Based on his training and experience, the officer believed the defendant was concealing contraband. A search of the trunk revealed a loaded handgun. Judge Flecher: Nervous? I get nervous when I see a spider. That doesn't mean I'm a felon. What's the articulable fact for the search? Prosecutor: The officer stated the defendant avoided eye contact, and the area is a high crime zone. Judge Flecher: That's a hunch, counsel. Being nervous in a high crime area while being pulled over by the police is called being human. Did he smell anything? See a holster? Prosecutor: No, Judge. Just the behavioral indicators. Judge Flecher: No. We're not doing this. Under the Fourth Amendment, you need probable cause to search that trunk, and fidgeting doesn't cut it. That weapon is the fruit of an illegal search. I'm finding no probable cause. Mr. Vance, you're free to go. Watch that light bulb, okay? Judge Fletcher's ruling reminds us that training and experience cannot replace the Constitution. Without a specific, legal reason to bypass the trunk's lock, the evidence is inadmissible under Article 38.23. Our second hearing takes place on January 15, 2026. Defendant Elena Moreno was charged with resisting arrest following a late-night traffic stop. The officer's report claimed Ms. Moreno was swerving dangerously and failing to maintain a single lane, providing the initial justification for the stop. Judge Flecher: Ms. Moreno, you're here for resisting arrest. You have the right to remain silent and the right to an attorney. Do you understand? Moreno: Yes, sir. Judge Flecher: All right, let's get into the probable cause. Why was she pulled over? Prosecutor: Judge, the officer observed the vehicle swerving across the yellow line multiple times on Highway 6. Upon stopping the vehicle, the defendant became combative and refused to exit, leading to the resisting charge. Defense: If I may, Judge, we have the dashcam footage synced to the record. Judge Flecher: Let's see it. I want to see this dangerous swerving. The court reviews 30 seconds of footage showing the car driving perfectly straight. Judge Flecher: Counsel, am I missing something? I see a car driving straighter than a ruler. I don't see a tire touch a line, let alone cross one. Prosecutor: The officer's report says. Judge Flecher: I don't care what the report says, I care what the officer saw. And what he saw was a ghost violation. This stop was illegal from the second the lights turned on. Judge Flecher, if the stop is bad, the arrest is bad. You can't manufacture a reason to pull someone over and then charge them for being upset about it. No probable cause. Case dismissed. Judge Fletcher's decision hinges on the fruit of the poisonous tree doctrine. If the initial traffic stop violates the Fourth Amendment, any evidence or charges flowing from that stop, including resisting arrest, cannot stand in a court of law. The final hearing we will review occurred on February 2, 2026. Defendant Julian Banks was charged with interfering with public duties under Section 38.15 of the Texas Penal Code. This statute is often cited when a citizen's presence supposedly hampers an officer's ability to perform their job. But as we'll see, the line between interference and exercising rights is one Judge Flecher guards closely. Judge Flecher, Mr. Banks, you're charged with interference. That's a Class B misdemeanor, carrying up to 6 months in jail. You understand your rights? Banks, I do, Judge. Judge Flecher, all right, let's hear the facts. What was he doing? Prosecutor, Judge, officers were conducting a felony stop on a separate vehicle. The defendant was standing on the sidewalk, filming with his phone, and refused to move back when ordered. The officer felt the defendant was a distraction and a safety risk. Judge Flecher, how far away was he? Prosecutor, the report says approximately 15 to 20 feet. Judge Flecher, was he yelling? Throwing things? Tripping the officers? Prosecutor, no, Judge, but he was verbally argumentative regarding his right to be there. Judge Flecher, argumentative isn't illegal. It's a hobby for some people. Look, the First Amendment doesn't take a nap just because an officer is having a busy day. If he's 20 feet away on a public sidewalk and not physically obstructing anyone, he's a spectator, not a criminal. Judge Flecher, this is a contempt of cop arrest. We don't lock people up in Harris County for hurt feelings. No probable cause. Mr. Banks, keep filming, just keep your distance. You're free to go. Judge Fletcher's ruling reinforces the Glick versus Cunniff precedent. The public has a clearly established right to record police officers performing their duties in public spaces. By finding no probable cause, the judge ensures that interference charges are not used as a weapon to silence citizens holding power to account. These 3 hearings demonstrate why the role of a judge extends far beyond the sentencing phase. In a justice system where the state holds immense power, the probable cause hearing acts as the essential pressure valve, ensuring that government authority remains tethered to the Constitution. As we saw today, Judge Fletcher's refusal to accept conclusory reports or ghost violations isn't just about the individuals in the room. It's about protecting the legal standard for every citizen in Harris County. When a judge identifies a violation of Article 38.23, they are sending a clear message. The law applies to everyone, including those who wear the badge. By scrutinizing the hunch and the pretext, the court reinforces the principle that an arrest must be built on evidence, not ego. These determinations are the front line of defense against corruption, ensuring that due process is a living practice rather than a stagnant promise. What do you think? Should more judges take this active approach in reviewing police reports? Or do you believe the system already has enough checks in place? Let us know your thoughts on pretextual stops in the comments below. If you found this breakdown insightful, please subscribe and share this episode. Together, we can foster a more informed society and keep the scales of justice balanced. Thank you for watching.
The Constitution isn't a suggestion. Do you agree with the judge? Drop a yes and subscribe for more.